Well, good morning. I just been informed that we're live, so we will go ahead and get started. My name is Michael Billock. I'm an attorney with Schoeneck King. Welcome to Monday morning, and welcome to the first webinar of our Manufacturing Week series. We are starting out today with cybersecurity, just a small little topic that is not much in the news lately. Of course, everybody has heard about the Equifax breach. We have seen news item after news item, Target, Yahoo, Equifax, and you do commonly hear that it's not simply a matter of if, but when, and which is true to some extent. But our job as attorneys, and your job and with your companies, is to make sure that that you're not low-hanging fruit when it comes to it. If for an analogy, if you have somebody that's looking to steal a car, you do not want to be the car in the parking lot that has the door open, the keys in the ignition, and the car is running. You'd rather have the car that is locked, windows up, keys are not there, so that they'll look for that car that has the door open and the keys in it, and they'll go after something that's a little bit easier than your automobile. With no further ado, we'll go ahead and get started. What we're going to talk about today is first the legal requirements, federal and state, and then we will we'll get into what you should be doing to meet those legal requirements. As I did mention before, this is the first in the series for the week, and you can see that what we have tomorrow, protecting manufacturing business from IP theft, and our additional items throughout the week. So we'll start out with just a little levity here. In terms of what your organization has, you could have the best virus software, the best firewalls, the best policies, and the best physical security. But in the other corner, we have Dave. And so human error is the cause of many breaches and cybersecurity incidents. So you could have the best technology, and yet if it's not implemented properly, or it simply takes one employee clicking on the wrong link in an email, accessing the wrong Wi-Fi network that somebody else has put some malicious code on, or anything in that regard. What we're finding out about what happened with Equifax is that they did have up-to-date, well, relatively up-to-date software, but they had not updated it for a security vulnerability that had come out. They hadn't patched it. And that's a human error issue in terms of not patching it in time. Obviously, we'll be finding out more in the coming months, but we're always very conscious of human error. So getting into that, in terms of human error, I mentioned that we'd be talking about federal and state laws. The interesting thing about cybersecurity law in the United States, unlike in Europe, is generally speaking, there is not much of an overarching, very specific cybersecurity law in terms of what your company must do. In the United States, it is industry specific. There are laws that apply to the healthcare sector. We have HIPAA. We have laws that apply to the banking sector, the financial sector, the higher education sector, many sectors. But as far as an overall cybersecurity and data privacy law, we actually don't have something that very specifically applies. What we do have is the Federal Trade Commission Act. Section 5 of the Federal Trade Commission Act, that requires you not to engage in unfair or deceptive commercial practices. So what we have here in terms of what you see on your screen, and we'll talk about what these enforcement actions involve, is that an unfair practice is one in which the company has information that is sensitive information, that is private information, consumer information, that the company has not taken measures to protect. And you can see in these enforcement actions that the FTC has gone after various employers, including GMR, BJ's Warehouse, and Eli Lilly, where the company didn't provide sufficient data privacy and security. It was a recent case against Wyndham Worldwide where there was a breach of Wyndham and the hotel company, and the FTC said, you've got credit card information of customers. And for some reason, you didn't feel the need to keep that information secure. You didn't have sufficient password security. You didn't have password length. There were actually some employees that even still had password as their password in this day and age. And the FTC went after them, said consumers that give Wyndham Hotels their credit card information have an expectation that information will be kept private, encrypted, and stored. And they hadn't done that. And the FTC considered that to be unfair. Deceptive is where you have a privacy policy. You state this is what you do to protect customer information, vendor information, and things of that nature, and yet you don't do that. So it's deceptive. You're advertising one thing and doing something else. And the FTC, as you can see in these enforcement actions listed on the screen, has gone after companies that engage in deceptive practices. So I previewed the Wyndham slide before going to it, and as I mentioned, in terms of the industry standard and reasonableness, as an attorney, what is reasonable is normally subject to interpretation, but that, in this day and age, again, requires something that encryption for credit card information, passwords, when talking about password information, and strong passwords. People don't necessarily know what is something between a strong password and a weak password. There's something called a brute force attack, and that's basically where the hacker is trying every single possible combination of letters and or numbers in order to get the password. And the shorter the password, the faster it takes to crack that password. If you only have a 3 or 4 digit password, shall we say, and it's only numbers, it just takes from 1 to 1,000. There's only 1,000 possible combinations. But if you add in letters into that, now you've got 36 different combinations. If you add in uppercase letters to that, now you've got 62 different combinations. And then if you add in special characters based on that, you've got any number of different combinations where once you keep multiplying that out by each successive digit, you get to a point where it takes a hacker a heck of a long time to be able to breach that password. And actually the difference between an 8-digit password and a 12-digit password is a difference between months and years in terms of a brute force attack succeeding. So you want to make sure that that you have strong passwords in that regard. So in moving on to the next slide, in terms of deceptive practices, I mentioned before that we have an example here with the Dwala company where they had represented that the consumer data was securely encrypted and stored in a bank-level hosting and security environment, except that it wasn't. In this action, interestingly enough, no consumer data was actually exposed, and yet the FTC went after the company regardless because finding it to have a deceptive practice. So you don't necessarily have to have a breach for the FTC to come after your organization, which is something that that you should be aware of. So federally speaking, we've got the Federal Trade Commission. You want to make sure that if you have a privacy policy, and you should have a privacy policy, that you are abiding by it. And you want to make sure that you are taking reasonable measures, and we'll talk about some specific reasonable measures later on, to make sure that you're protecting your consumer information and your vendor information, because if not, the FTC could find that you've engaged in an unfair practice. So now talking about state law, talking about New York. New York has a state-specific law that requires protection of Social Security numbers. So the overall requirement in New York is that you should not be disclosing Social Security numbers to the public, and you should not be requiring the use of Social Security numbers. But of course, the exceptions sometimes swallow the rule, and it is subject to various exceptions. Having said that, you shouldn't be printing Social Security numbers on cards or tags, or encoding them in a document. There are still a number of companies out there where somebody's name tag might have their Social Security numbers on it, or have a barcode where, if decoded, that would be the employee's Social Security number. and that is precluded by law. That is unlawful. And also, when talking about Social Security numbers, the way that this law works, it is the Social Security number or a number derived from the Social Security number. So that means, and it's very common in this day and age, you are asked for the last four of your social. Again, you should only be asked for that when it is one of those various exceptions, because that is unlawful. The Social Security number law does cover just talking about the last six of your social or last four of your Social Security number. You can't require transmission of a Social Security number over the internet. There is an exception if it's encrypted, that is allowed, but not if it is unencrypted. You can't require use of Social Security number to access a website, and you should not be printing Social Security numbers on materials that are sent by mail. Again, you may see sometimes Social Security number blacked out except for the last four, but strictly speaking, that does not comply with New York Social Security number law, because that is derived from a Social Security number. You also have to protect Social Security numbers within your possession, and that includes having those reasonable measures to limit access. So what are those reasonable measures? That's to borrow basically from the healthcare industry. Measures can be administrative, technological, and physical. So we'll start with technological in terms of making sure that Social Security numbers, whether they're stored, are encrypted, and if to the extent that somebody can access them, that they're password protected and with a strong password with access. When we're talking about administrative controls, those are policies in terms of controlling who is able to access Social Security numbers. You definitely shouldn't let any employee in your organization have access to this information that you have in your possession. It's only those employees that have a need to access Social Security numbers should have that permission to access Social Security numbers, and there should be a policy in place for that as well. And finally, I mentioned physical. Physical measures are what they sound like. Social Security number information, they should be kept in a locked filing cabinet, but that's no good if you've got the filing cabinet that's open and you have an office that's open. That it should be in an office that's locked and not able to be accessed by anybody other than those that should have access to Social Security numbers. And you have to provide necessary and appropriate safeguards to protect confidentiality. And as you can see, the penalties for violating this can be high, as much as $250,000. So you want to make sure that you are abiding by this law. So one of the first takeaways you see here is to encrypt Social Security number data whenever possible. I've mentioned encryption a few times, and I don't think I've specifically stated why, is that encryption, generally speaking, for most laws that you're going to come in contact with, whether it is the FTC, whether it's this New York law, whether it's other state laws, is I'm trying to think of another phrase right now, but I can't think of it, so I'll just say it. It's basically a get out of jail free card in terms of if you drop a flash drive or an employee drops a flash drive with your employee's Social Security number information on it, your customer's Social Security number information on it, that is going to be a data breach unless that information was encrypted, such that somebody that gets that flash drive cannot access that information. So many things that would be a data breach in terms of Social Security number information or other information that we'll talk about will not be considered a data breach if that information is encrypted. So you do want to encrypt Social Security number data whenever possible. You want to make sure you have adequate policies and procedures in place. We'll talk about that. We talked about limiting access to Social Security numbers and reviewing any use of Social Security numbers that you have on ID cards, encoded, last four. You don't want to be using this information if you do not have to do so. And to the extent that you have employees in other states, you want to make sure that you're considering any legal requirements of those states when it comes to Social Security number information. As I mentioned before, this is a state-by-state patchwork. So we've got 48 states. I don't know what's going on in Alabama and South Dakota, or potential legislation they have there. But we do have 48 states. DC, Guam, Puerto Rico, and the Virgin Islands do have legislation requiring entities to notify individuals, and we'll talk about other parties, of breaches involving personally identifiable information. But here's the issue. Personally identifiable information is defined differently in each state. In some states, it's Social Security number information, driver's license information, financial information, credit card information. In other states, it can be that information plus additional things, or it's a smaller subset of information. So whenever we have an issue where we've got a client that suspects that they have a data breach, somebody lost a laptop, lost a flash drive, something in that regard, our first question is, who was affected? What customers are we talking about? What states are those customers in? Because believe it or not, we have to go by and look at the laws in these various states and see, number one, is the information that was disclosed, is that the personally identifiable information as defined by that state law? And number two, if it is that considered a data breach? Because in some states, it's a data breach only if you have reason to believe that it is going to be maliciously used or wrongfully used. In other states, it's a data breach if you believe the possibility exists that it could be wrongfully used and you can't account for it. So it is different. I will say when we do advise clients to that extent that they have something that affects customers or vendors in multiple states, that we go by the lowest common denominator. If there is one state where it has affected, we do have to do breach notifications, we're basically going to notify all the customers or all the vendors, even if some other states we wouldn't necessarily have to do so, because you don't want to be in a situation where you're notifying some of your customers but not notifying others. Okay, so, well, here we are in New York, and we have our various offices in New York. I'm actually presenting today out of our new Saratoga Springs office, and so we're going to talk about New York State notification requirements and when it is and is not a breach in New York. In terms of who must comply with New York's breach law, we're talking about state entities, individuals, businesses that operate, maintain computerized data. That includes private information. Now, how New York law defines private information is Social Security numbers, driver's license number, a credit card number, or a financial account number in combination with the pass or security code to the amount. So again, Social Security numbers, driver's license number, credit card number, or a bank account number that's in combination with some sort of code to access to the account. If that information is released, then what's the duty to notify? You have to notify those whose information was disclosed. And you have to do that without unreasonable delay. So you want to make sure that you are proceeding expeditiously, but you also need to proceed cautiously. So you want to make sure, because you don't necessarily want to put out information that you've had a data breach if that's not the case. So you can take a little bit of time to research to make sure as to whether you have a breach or not. The law does specify the method of notice. It can be done by mail, can be done electronically if it's consented to, and it can be done by phone if keeping a log of the phone calls that you have. But again, as a lawyer talking, we always like documentation. So if you are going to notify people by phone in order to do it as expeditiously as possible, you're going to want to follow up with a letter to make sure that you have included, you have a record that you've notified everybody you need to notify. You can do substitute notice if you are notifying a lot of people in terms of giving notice to the media, doing notice of posting. But we're talking about, as you can see on the slide there, a heck of a lot of people. If it would cost more than $250,000 to mail out notices to everybody or call that many people. And if you have provided notice, you're providing notice to New York State residents. If you provided any notice to them, you have to notify the State Attorney General's office, the State Consumer Protection Board, and the State Office of Cybersecurity. So again, it's something where you want to take the time you need to take to see if a breach actually happened, because if a breach happens, you have to notify these agencies. But if you found that that did happen, you need to go ahead and do that as expeditiously as possible. So what needs to be in the notice? The notice has to include contact information of the person or business making the notification. It has to include a description of the categories of information that were reasonably believed to have been acquired by a person without valid authorization, including specifying which of the elements of personal information and private information were or reasonably believed to have been so acquired. When I mentioned before about private information is defined in different states. In New York, you have that private information, social security number, credit card information, driver's license information. But in order for it to be a breach in New York, it has to have been acquired by a person without valid authorization, is the standard in New York. So, as I mentioned before, that is New York standard. In other states, it's not something where somebody has acquired it. It can be something where you reasonably believe that somebody has acquired it, or that somebody has simply accessed your system. So those are the federal requirements and the state requirements in terms of your requirements for keeping social security number information safe, for other private and personal information safe and protected, and if you do have a breach, what you have to do. But of course, you want to know, okay, that's if a breach happens. We don't want a breach to happen. So what should we do to prevent that from happening? Well, you're going to start with a risk assessment. And the first thing you do with a risk assessment is to find out what information do you have. To the extent that you have social security number information, to the extent that you have credit card information, driver's license information, other private information as defined by New York and as defined by any states in which you have customers, vendors, employees, and the like. And what you want to do is identify your risk and vulnerabilities. What this is going to look like, basically, is like an archery target with a bullseye. You want to have your most sensitive information at the middle of that bullseye, and that is going to have the highest security and the fewest number of people be able to access that information. Going out from the bullseye will be less private information, and with more people having access to that. That is how you should have your system designed, your network drives designed, so that you are controlling who has access to the most sensitive information. It's always a balance between security and operations. You could have the most secure system in the world if you simply cease to operate. You wouldn't not allow any employees to operate any computers, log in, use mobile phones, etc. But you need to operate. So you need to have employees have access to the system. So what you're trying to do is to make sure that you can still operate as necessary while engaging in the security and secure systems that you need to engage in to make sure that you're minimizing the risk of breach whenever possible. And you have to be aware and cognizant of the fact that you could have a situation where employees, in order to get something done, may try to bypass any interlocks that you have. Maybe there's something where a document is password protected, so it can't be modified. So you have an employee that goes and they print it out and they scan it in and then convert it to Word, so that new document is not password protected and they can modify it. Things of that nature you have to keep in mind. If you were an employee and you were getting stymied by these password requirements, login requirements, what might you do to try to get past an interlock, and then make sure you're training employees not to do that, and training and putting in additional interlocks as necessary to prevent that from happening. Getting back to the risk assessment, again, you've sort of gathered all the sensitive and private information that you have, and you want to make sure that you're controlling, who has access to that information. But one of the other things that you need to inventory is who who has devices? Who could possibly access that information? You've got employees. If any employee can log in remotely, they're doing it from home computers, they're doing it from iPads, doing it from phones. Do you have any idea the number of devices that can access your system and the number of devices that have your work documents on those devices? So you want to have a device inventory where employees, you can require employees to disclose to you any and all devices that they are using to log into the system, and you're going to want to put some procedures in place so that when they're using those devices, that they're not making your system vulnerable. If they have your work documents on their iPad, on their phone, and they go to an international airport and they're using the Wi-Fi, your information is at risk. It could be compromised, or something could get on their phone or system, and when the next time they come back to the office, it's uploaded to the office, and you can be at risk there. So you want to make sure you do that device inventory. Consultants and vendors, what, if anything, are you requiring of them to make sure that their systems are as secure as your own? You could again have the most up-to-date virus protection software, malware protection, firewalls, things of that nature, but you've contracted with a consultant or vendor, and they submit information to you electronically, and when they do so, there's something that comes into your system and allows your system to be accessed. That's how the Target breach happened. It was not a direct attack on Target. It was an attack on a vendor that they used that had an electronic relationship with Target, and that's how the hackers got into Target. And one thing you should be aware of in terms of your organization, you might be a member of a small organization thinking we're safe, we're not a large target. Well, it might be true that you're not a large target, but just because you're not a large company doesn't mean that you are not a target for hackers and for disgruntled employees or things of that nature, because you could be used as a platform to get into another organization. They look to you because they figure as a small organization, you likely do not have the cybersecurity controls in place that a larger organization might have. You want to be aware of human, environmental, and natural threats. I mean, the human threats, we talked about, Dave, in one of those first slides. But environmental and natural threats are what happens if the power goes out to your servers, to your organization going down. Are your servers vulnerable to a physical attack or to some other sort of attack? And in terms of a physical attack, talking with cybersecurity experts and governmental cybersecurity experts, again, you could have many electronic interlocks in place and firewalls in place. If somebody can get physical access to your machine, they can control your machine. They can put whatever they want to put on there through a flash drive, through a USB port. One exercise that cybersecurity experts and vendors engage in, and because hackers engage in it, will be to scatter 2 or 3 flash drives in a parking lot outside your building, and see, employees will pick them up. Hey, free flash drive, and plug them into your systems to see, hey, what's on this flash drive I just got? Is it blank? Is it not blank? Well, what they just did was put some malicious software on your system. So you want to make sure that you have controls in place where that cannot happen in terms of a physical threat. You want to assess the severity of the impact of any potential security breach. What happens if you do have a breach of a local system? What happens if you get ransomware on your system? Are you conducted? The only real defense to ransomware is backups, is in terms of being able to get your information back. Most ransomware has such high encryption that your only 2 options are either to pay the ransom or to go back to a previous version of your system where the ransomware is not on it in order to back up and restore your information. So it becomes a question as to how often are you backing up and what are you backing up? If you do have that security breach with ransomware, how long would it take you to get back online? Obviously, you're going to assess your security system and the practices that you currently have in place, and you're going to tailor, again, the risk remediation and management based on your goals. like I said, you could have the most secure system on the planet simply by not operating. So you're going to look into a trade-off as to operations versus security. So when talking about policies, I talked about those three types of safeguard: administrative, physical, and technical. Now we're talking about administrative. We're talking about the policies that you want to have to make sure that you are protecting your data as necessary from employees. You want to develop a policy to limit access to sensitive data only to the employees that need that access. Set up a process to determine who should have that access, who's controlling that decision in terms of who has access to that information. You want to adopt procedures and systems to restrict the access sufficient to the level of authorization granted. And you want to monitor that access. If you have this policy in place and yet you're not conducting any monitoring, the policy probably isn't that good or that effective. You want to have a system in place where you've, and it can be a combination of automation as well as people monitoring the system. You want to have a system in place where if you've got a business that operates from 8 in the morning till 8 at night and somebody's accessing your system at 2 in the morning, 3 in the morning, you get notified right away. That's a huge red flag. If you've got a system where you need to shut off employees' access when they are no longer with the company, that is a very large source of data breaches, disgruntled former employees logging into your system, and that goes back into the risk assessment. When you are determining what information you have, what devices are out there, you also want to be determining who has access to your system. If you were to look at a list right now of who could log into your system at your work site or remotely, you might be surprised by some of the people that are on it. You might have former employees, you might have former vendors who you no longer have a relationship with. And you want to have a system in place of automatic monitoring of if somebody is no longer with your company, no longer has a relationship with your company, is logging in, that you are immediately notified. And you also want to have people looking at that. So to the extent that you've got somebody that's accessing systems repeatedly over the course of several days, when it should be something that should only take 1 look or 2 looks to get that information, that could be a signal that you've got some malicious software in your system that's repeatedly accessing information that it shouldn't be accessing. And you want to make sure that you are training employees as soon as they come into your workplace, as well as periodically. A system that you can have in place is something where employees have to engage in training at their computer every month or every 2 months. And if they don't engage in this training, it basically locks them out. And the only thing they can do before trying to log into their system again is to get that training to make sure they are up on the latest in privacy and cybersecurity. And to make sure that when systems change, technology changes, new threats arise, they're being updated. If you have employees that have iPhones, that when the new update comes out, you're requiring them to install that update, because that update's going to have a lot of patches and bug fixes that to make sure that your system has the latest antivirus software and things of that nature. Viruses and malware, it's incredible in terms of how many are created every single day. If your computers are a week out of date, that's a bad sign. If they're a month out of date, that's a terrible sign. Again, I mentioned about Equifax. It's looking like the patch that was involved or the patch that could have saved them was 2 months out of date, which is a significant length of time. Again, we'll find out more about that in the coming weeks and months. You want to make sure that you are requiring employees to acknowledge receipt of their security obligations or policies, so that if you are going to discipline employees for not doing what they're supposed to do, that they come back and say, well, I didn't know. I didn't know I was supposed to make sure that I had the most up-to-date software. I didn't know I wasn't supposed to access that information. You have their signed acknowledgement saying that they do know about it. You want to make sure that you've informed them that violation can lead to discipline. So a little bit of history about myself. Before becoming an attorney, I was in the Navy. I was in the submarine force, and submarine force was basically single-handedly put together by an admiral long since departed. His name was Hyman Rickover, that built the nuclear navy. And one of his most famous sayings was that if at the end of the day, you can't point your finger at somebody and say this person was responsible, then nobody was. And taking that to heart, you want to have somebody in your organization that is responsible for cybersecurity, because if you say this is something that we should do, this would be a good idea to do, why don't these departments take a look at this? It's simply not going to happen. You need to point to somebody and say, you're in charge of this. You need to make this happen, and you're in charge of implementing these policies. You're in charge of, you give them the resources that they need to do, but you want to make sure that that they're in charge of it. And you don't want to point at somebody willy-nilly. You want to make sure the person has sufficient training in terms of knowing what it is that they need to do. You want to give them sufficient authority so that when they tell senior people in your organization that, yes, they too need to make sure that they're not using public Wi-Fi or something in that regard, that they'll listen to them and not just ignore them because they're not senior enough. Speaking of public Wi-Fi, by the way, I mean that is a prime a vehicle for hackers to access your system. There are articles out there about you go to the Marriott hotel, you log into Marriott public Wi-Fi, your phone now recognizes Marriott public Wi-Fi, and hackers, believe it or not, will send drones into areas where spreading a Wi-Fi signal, broadcasting a Wi-Fi signal, looks like Marriott Wi-Fi, and your phone will automatically hook up to that drone, to the Wi-Fi provided by that drone, things of that nature. So I don't recommend on any mobile device like a phone or an iPad using Wi-Fi unless you have separate encryption software. For laptops with public Wi-Fi, again, we get to that question of operation versus security. You can use public Wi-Fi if, again, you are using an encrypted connection, such as VPN. Recognize if you're not using a VPN connection on a laptop in a Starbucks or at McDonald's, any public Wi-Fi, that what you're seeing doing broadcasting information can be seen by anybody else in there. I mean, there have been articles out there, somebody goes into a Starbucks, they've got a device on them that looks like the Starbucks Wi-Fi, and everybody's logging onto their device as opposed to the Wi-Fi router in Starbucks. Sorry about that, little diversion there. There's a lot of information to put out. In terms of, again, getting back to the security or senior officer, what's the reporting relationship? If they need to get resources, do they have to go through several levels of red tape, or can they just go to the head of the organization to get the resources that they need? Are they reporting to the head of the organization or board periodically about what they're doing? Are they involved in business decisions, and to make sure that they know that these decisions are the effect they might have on your organization's privacy policies, and do they have access to the legal resources, technical resources that they need to have? Third-party agreements. So I mentioned before, you've got you're dealing with contractors, you're dealing with vendors, and if you don't have an agreement with them that requires them to have the same level of security that you have, you're putting yourself in danger. And you definitely can require them to have comply with the same amount of security that you have. You can require them to give you notice if they're breached, to go ahead and let you know that they've been breached. And you also want to put in their indemnification requirements. If they have been breached due to fault on their part, and you're going to be sued for breach by somebody, that they are going to indemnify you and pay your legal costs and possibly pay any damages that you might be liable for because it was their fault. Talked about the minimum necessary security practices that you want them to have, and you want them, if they are going to contract with somebody else or subcontract with somebody else, again, you don't want them to subcontract with somebody with lesser security requirements that can then breach them, that can then breach you. So you want to make sure that any obligations that you're giving to them, they're passing in terms of security obligations, they're passing on to their subcontractors. You want to require return or destruction of any sensitive data that you're providing to them at the end of the agreement. and the right to audit their security practices and systems. They might say, sure, we'll do that, no problem, and they're not doing it. And you want to make sure that you have the ability to check and make sure that that they're doing it. Examples of cybersecurity policies, we will talk about this in detail. Electronic system acceptable use policy, policy on mobile devices, termination procedures, and a data breach plan. An acceptable use policy for your employees. How many employees do you have that when they step away from the computer, they lock their computer as opposed to leaving it open and available for anybody to see? You want to clarify to them that with their computer, with anything that they are doing on your network, they have absolutely no expectation of privacy, that you can monitor anything that they are doing on your computer, on your equipment, on your network. You want to define what unauthorized access is. You want to make sure that you're defining that to the extent that you can access, again, monitoring, you can access their email, but you want to let them know what the limits of their authorization is, and make clear that if they are accessing, say, your financial information, other employees' personal information, that is unauthorized and they don't have the ability to do that. You want to make sure that they are passwords. They're only using their own password. They are not, employees are not sharing passwords, and employees don't have the ability to use others' passwords. To the extent that you're limiting data for various sectors of employees, that's contained in your policy. Limits for external media devices, to the extent that you have ports on your computers, USB ports, flash drives. You can set a policy that no flash drive, no outside external hard drive can be hooked up to your computers at all. You can set a policy that nothing could be downloaded, that they could be hooked up, but that only a blank encrypted device could be hooked up, and that anything that is going to be downloaded needs to be authorized by the company in advance, with defining the person is who's going to authorize it, and also limiting or defining what information could be put on an external device, and again also limiting any downloads from third parties. Talked before about workarounds that employees might do. Well, I can't download this, so I'll just print it out. So again, want to make sure that you've got a policy that about sensitive printouts, not leaving the workplace, and if you're printing out, your employees are printing out sensitive information, information about whether it's customer lists, whether it's financial information, whether it is credit card information, that it's not just put in the recycle bin, that it has to be shredded after use. You want to make sure that if an employee does see something that's suspicious, they know where to go, and that there is a reporting procedure. So you could consider restricting personal use of the company system, that employees can't use your system at all for any personal use, no Amazon shopping, no looking at the weather, no checking the news, things of that nature. If you'd like to do that, you certainly can. Or you could limit certain types of systems or certain types of websites that your employees might go to. So they can't go to a personal email site, such as Gmail, Hotmail, game sites, things of that nature. So that's something that you want to consider. Password policies. I talked about the brute force attacks before. The longer your requirements for a password, the stronger they are, the less likely they could be hacked. You can require them to be changed frequently, and you can require a multi-level system access, especially for remote access. And that's something where it's more than just a password. So an employee has to have a token on them that has a randomly generated number. So if they're trying to log in, not only do they have their password, something that they know, but something that they physically have on them. You know that they have the token on them if they have to input the number that's randomly flashing on the token, or something instead of an electronic token, that they get a text message on their phone or with that code, something in that nature. So you know it's them, that they have that knowledge, not just the knowledge, but their physical cell phone or something like that on them. You can also require them to use a unique password for their system. I mean, you can require your employees to do many things. In this regard, you can say, listen, you cannot use any password that you have for any other site, because you don't want to have a situation where if the Yahoo is breached and somebody knows what their Yahoo login information is, they try their Yahoo password on your system, and lo and behold, they can go ahead and get in. A mobile device policy, you can require employees to auto-lock the device with password and encrypt the data. So if you do have employees where either you're providing the mobile device to them, or they are bringing it to your organization and they can access your organization's email and things like that on their phone, you want the phone to automatically lock. You don't want it to be a situation where they leave their phone out, somebody steals it, and they can get your information without putting in any sort of a code. Likewise, if that does happen and somebody's mobile device is stolen, these things are, well, I guess we're getting a little bit in the other direction with the iPhone 8 Plus and the phone sizes, but some of them are relatively small and they get lost. And you want to make sure that employees report to you immediately when any mobile device is lost, because you want to make sure that your information is safe, and you want to have the ability possibly to remotely wipe that phone or that mobile device if you're worried about that information, even if it's encrypted, into getting into the wrong hands, to have the information to you remotely access the phone so that you could see where it is, number one, and or to remotely wipe the phone so that any sensitive information on there can be removed immediately. And as mentioned before, you can prohibit public Wi-Fi use for employees. You cannot, if they have a phone, whether it's their personal phone with your work information or it is a phone that you've given them, so long as they're using it for work purposes, you can prohibit them from using public Wi-Fi. You want to make sure that employees know that and have them acknowledge that they've received these policies and that they can be disciplined for any violation of these policies. So for any employees that have been they've been suspended because you're investigating them or you're terminating them, we deal with this conversation with employers all the time, especially in situations where they might be terminating somebody that has high-level access or somebody that's working in IT. You want to make sure that before you have that discussion with them about suspension or termination, you've turned off their access. Believe it or not, in this day and age, I still come across situations where somebody terminates an employee goes back into their office, they download things, they send out the, even if it's just sending out the mass email to everybody saying about how they were fired and they hate this place. You don't want to have a situation where an employee still has access to your system after they're terminated. And you want to coordinate the termination in a way where you make sure you are getting back all laptops, mobile devices, everything with company data. You don't want to have a situation where you've terminated the employee and then you're trying to get that back. You're asking them to give it back. You're threatening them with legal action. When it comes down to it, you have to go ahead and sue them and seek enforcement, seek an injunction where you can go and get that those things back from them physically if they won't return it voluntarily. So you want to make sure you get it at the outset when you're having that meeting with them. And to some extent, depending on the situation, you may want to check, what have they, and maybe they didn't download anything. Maybe their access was terminated. Have they been sending emails to their private home, Yahoo, Gmail, or home email address? You want to check on that as well. So in terms of cybersecurity breach, you don't want to have a situation where you find out that you've been breached and you're looking at each other not knowing what to do, not knowing what the first thing to do is. So to the extent that you have that person in charge, you want to have, whether it's that person or somebody else that's going to lead the team in the event of a breach. And you want to say who's going to be on that team. You're going to want to have somebody from IT. You're going to want to have somebody from HR and or legal. You want to going to have the appropriate players there, and you want to have them excuse me, that contact list so that they can be contacted quickly, cell phone or otherwise, in the event of a breach. You want to make sure that you have a plan in terms of preserving data relating to any intrusion, to make sure that if you're recreating this later, if you have to turn this over to law enforcement, if you're going to have to take an enforcement action against an employee, if you're going to have to report to the state about what happened, that you're doing this in a forensically sound manner, that you're not basically trampling on the evidence at the same time that you're gathering it. And you want to make sure that you know the notification procedures as to who you have to notify, what needs to be in that notification, and when. As I mentioned before, New York has that safe harbor rule that any information that is protected by encryption generally won't be subject to any of the data breach notifications, unless, of course, somebody has the encryption key so that they can get the data. And any of that personal information should be encrypted. So, giving you some ideas in terms of what you should have in terms of policies, things that you want to do in terms of training your employees, or requirements that you have for employees, but you want to train them on it. You want to make sure that you're training them when they arrive at work and periodically thereafter. And you want to let them know how employees can accidentally cause those data breaches. Those flash drives, those things are small. They fall out of pockets in cars. They fall out of pockets on planes. They fall out of pockets with holes in them. And that's the lost flash drive and the lost laptop have led to millions and millions of dollars of fines for when we're talking about hospitals and things of that nature for HIPAA breaches. But they can also result in very large damages and liability for your organization to the extent that if they do have that SSN information on it or that other personal information on it. The malicious email. So everybody knows about phishing, P-H-I-S-H. And that is something where somebody sends the email and it looks like it's addressed to you and it says, hey, I haven't talked to you in a while. I thought you would appreciate this link, and here's the link. Right? Everybody sees that. Everybody knows about it. Believe it or not, employees still click on that. There are the hackers and the spammers have gotten smarter. They will do what's known as, believe it or not, these terms are called whaling or spear phishing, where they use social media, they use news sources and they use any other resources that they have to find out as much as they can about their target and that high-level people in organizations, and then they will send an email to that target. It looks like it's from somebody else senior in their organization that says, hey, regarding this deal, this company wanted to accelerate this payment, just needed the authorization for this, and it's whether it's responding back to the email with the authorization and the account number, whether it is clicking on something just for that electronic signature or something in that regard. You have to be careful. You have to make sure that every single email, you are looking at that email address. Anytime you're asked to click on a link, open a document, things of that nature, that you are very keenly aware of who it's coming from and what it is you're opening, what it is that you're clicking on. And you want to make sure that you team up with IT to do it in terms of lessons that they've learned from breaches in your organization or from other organizations. As far as ongoing processes, you want to make sure that you're reviewing these things regularly for any potential improvements. And to the extent that you keep getting transfers, new employees in your organization, you're training them. And you want to test employees' responses. So what some cybersecurity vendors will do is penetration testing. As I mentioned before, they will scatter flash drives in a parking lot, see who picks them up, goes to put them in the computer. They will see if they can physically get into your organization. Will somebody let them in so they can walk around and stick USB drive devices in your computer ports. They will send those phishing emails to your employees to see who clicks on them, and you can have some additional information that way to see if your policies are working. Are employees clicking on these? It is like missile command, right? You could have 50, 100, 200, 500 employees. One clicks on it. You could have 99% of employees in compliance. One clicks on the malicious link, and that's all she wrote. So takeaways, you want to make sure that you are encrypting any private information that you have on your systems. You want to make sure you're reviewing your practices for protecting your employee data, revising your cybersecurity policies as necessary, monitoring compliance, training employees as necessary. And if a breach does happen, you want to have that breach plan in place beforehand. First, you're going to, like a plumber, you're going to find out, okay, what's the extent of the breach? You want to patch it to you're plugging the leak, find out what was released. And then afterwards, you're surveying the damage, looking to see what happened and who do we need to send these notices out to. That's what I have for today. I've got a Q&A button here, and I'm going to see if I can read these questions. I'm squinting a little bit if you see me on the screen. So, okay, we have a scenario. First question we have is a scenario if we had a vendor that we had confirmed as PCI compliant, and PCI is a standard where you're using credit card information that's put out by the credit card companies. It's not a law, it's a consensus standard. Anyway, going back to the saying, we are PCI compliant. Our vendor was breached via their equipment, and we were not directly breached. What is our obligation as far as reporting, or is it up to our vendor? So had a vendor that was confirmed as PCI compliant, the vendor was breached via their equipment, and the company that's asking me this question was not directly breached. What is their obligation for reporting? Is it up to the vendor? It depends. I mean, and I hate to use the lawyer answer of it depends. It depends upon what information. It depends on how many customers you have from which states, because there might be some states, or there are some states where do you have a reasonable belief that your customer information, even though it was on the vendor's site, has been accessed by others. And if that is the case, you may have a breach notification requirement. It also is separately from, you also want to check the agreement that you have with the vendor in terms of their notification requirements to you, the indemnification requirements, if any, that they have to you, and whether they've agreed to handle or help you with any notification requirements that you might have. So I've got another question to talk primarily about Social Security numbers, but what are the obligations for financial numbers, EIN, such as on W-9 forms, sales tax forms, et cetera, and also customer information, customer vendor information, such as drawings and specs. The law in New York only applies, believe it or not, to the Social Security numbers. Doesn't apply to the employer identification numbers, such as on W-9 forms. So technically speaking, an EIN is not private information. And you can find employers' EIN numbers online. If you look, any nonprofit employer, you can find their employer identification number online. It's listed on their Form 990s, which are available publicly. So those are not considered private information. Customer vendor information, such as drawings and specs, those would not be, generally speaking, considered private information pursuant to federal or state cybersecurity laws, but you may be liable under other laws, such as for trade secret misappropriation or something in that regard, if you have drawings and specs that you shouldn't have, or to the extent that if you didn't protect them and there was an expectation of protecting them, there could be some sort of an action under trade secret law. And every state's trade secret law is a little bit different. There is the Defend Trade Secrets Act, which just came out recently, but which federalized that law, but there are certain other requirements in order for that law to apply. So generally speaking, drawings and specs wouldn't be subject to a breach notification law, but there could be separate liability based on not not protecting that information, especially if there was a contract that covered that, you could be subject to a breach of contract action in that regard. The question about will the slides be made available for further review after the webinar? I believe the answer is yes. I think that after the webinar, from my experience at least, a link should be set out with the sites. If not, I'll make sure anybody that would like to get the slides up, and I'm being told via chat that the answer is yes. Slides will be made available. So those are the questions that I had, and it looks like we finished just in time. As I mentioned before, we've got tomorrow is protecting your manufacturing business from IP theft with Jeremy Ozek. Wednesday is wage and hour traps for manufacturing with Aaron Torcelio. October 5th, Thursday is avoiding OSHA liabilities with Stephen Ricca. And Friday, you've got navigating immigration issues in the manufacturing industry with Caroline Westover. So thank you all very much. I hope this was informative, and have a great day.